this committee has been that Damon and I are now co-chairs of the Criminal Justice Committee. And we have found a way to have regular meetings over lunch. I gotta say, if you want to have a good, strong committee, include lunch, and it really makes a nice difference because you have that extra incentive for getting together. And it's working out. It's working out. And one of the products of our collaboration actually is the setup for tonight.
Yes.
And so I'm going to turn this over to Damon right away so he can introduce our guests and we can get on with this show.
Yes. Good evening, everybody. Good evening. Thank you for coming out, and I want to thank Bart for allowing me to be a part of the Criminal Justice Committee and putting my little 2 cents and how we could inform the people of Greenberg, White Plains, and better Westchester what's actually going on in our criminal justice system. And I want to make a quick note. I want to recognize my brother Neil from New Rochelle Police Department, and hopefully at the end, we want to have him come up here because there's a test coming up for New Rochelle police officers. And I think it's very important to get our young people of color, men and women, on the police forces. It's definitely important. And if you want to go to blackwestchester.com, what it was 2 weeks ago, AJ, we had Neil and we had Charles from Yonkers Police Department to talk about the importance of having young men and women of color and the need, especially in Yonkers and New Rochelle, and Greenberg, White Plains, all the 43 municipalities, to have more people of color. Because I got 28 years on the job, and I'm looking at the front door, and I would like to see more young people to actually come on the job. Historically, the Department of Corrections employed more black men than any other civil service department without Westchester County, but that was in the 90s. You know, those numbers have actually reversed. So we still have a lot of work to do. And also tonight, I believe at the county center, they're going to try to vote on overturning Astorino's veto on the immigration bill. That's very important.
That's happening right now.
Yeah, it's happening right now. That's very important because of the fact that they're not trying to make Westchester a sanctuary city. The only thing they're saying is that Westchester police officers will not assist ICE in rounding up undocumented. And what will happen is that if I am undocumented and I see you get robbed, I'm not calling the police. I'm not going to call the police because they're going to come take me away. They ain't even going to care about you getting robbed. They're going to take me away. And that and what that does is actually makes the immigrant community more dangerous. It's backed by the Chiefs Association and different law enforcement organizations which oppose local law enforcement working with ICE. And whatever Astorino's talking is actually falsehood. To actually say that it's going to make the communities better. No, it's going to make them more dangerous. It's going to give that criminal element really free reign because nobody's going to call the police. So, on that note, so definitely stay on your local legislators to definitely overturn that veto, and if so, amend the legislation so the legislation will pass. Moving right along, we wanted to talk about tonight to discuss due process in the criminal courts. In the overall discussion of mass incarceration, one of the greatest things is our children are being arrested. And in the process, they have to go to court. And we have been seeing, which has not been reported, violations in that process. And I had asked Lauren Razor, and I've asked my brother Peter Davis, which I've known him in Woodlands High School, you know, which I know him way back at Woodlands High School, to come and talk about that. So I need to pass the mic over.
Yes.
Because we don't have another mic.
But no, the mic died.
It's all right. I can turn my voice up. I just want Lauren and Peter to introduce yourself and just give a brief background on who you are and what you do. And start with you, Lauren.
Good evening, everyone. I'm glad you stayed. I know it was a long meeting, so I really appreciate your being here. It's a very important topic about due process. I am a practicing lawyer. I have my own practice, and I just left an counsel position to a Wall Street firm. I was the corporation counsel of the city of Mount Vernon under the former Mayor Davis. I'm not laughing at Mayor Davis, but the situation in Mount Vernon is kind of interesting. I also was an assistant district attorney. I started my career under Robert Morgenthau, the Manhattan district attorney. I also was an assistant corporation counsel for the city of New York and rose as the senior trial counsel and the deputy for the city of New York. I also worked for the famous or infamous Elliot Spitzer. I was the chief of the Harlem regional office, which the jurisdiction was 96th Street North, and I handled all consumer fraud cases, and I brought consumer fraud cases on behalf of the people in that jurisdiction. One of the biggest cases we've had, which had over 200 victims or more, was an auto auction dealer in the Bronx called the Triborough Auto Auction Dealer, and we were able to put a stop to some of the unscrupulous practices. So I have been, in private practice, I have been called upon. I feel like my private practice is a calling. My most famous case is the one that just took place in White Plains. The reason why it was somewhat famous, whatever, it made the newspapers, but it was the most troubling case that I've ever seen in this century. I respect my brother here because he is on the front lines doing as much as he can to stop the mass incarceration. But I can tell you that there's serious issues, and I'm sure we're going to get into it and talk about it. But specifically, I have developed a blog talk station as a result of it, so I can give free legal advice through my blog because the community, as I see it after that trial, and although I know it, after that trial, I really, it continues to haunt me. And I handle civil rights cases, and I have a general practice, but I handle a lot of civil rights cases on federal court and state court. That's pretty much my background. Thank you. Oh, pass the mic.
Thank you. That's a hard act to follow. My name is Peter St. George Davis. I'm an attorney. I've been in practice now for going on 24 years. I started as an assistant district attorney here in Westchester County, originally hired under Carl Fergari, and he was on his way out. I was hired by Jeannie Impero, rehired as an assistant DA. After I left the DA's office, I worked with, I did a brief stint in legal aid as a staff attorney in Manhattan, and then I struck out on my own, and I've been out on my own in private practice for over, since the late 90s until the present. And I've been located in Mount Vernon ever since. I've done federal trials, I've done state trials.
Excuse me, I'm having trouble hearing.
Okay, I'll speak up.
You gotta really.
Yeah, you have to be a bit closer. I've done state trials, I've done federal trials, trials all over New York State. Everything that you can imagine, double homicides. I've represented serial killers, drug dealers, rapists, all kinds of cases that you could possibly do. A lot of times, and I'm going to talk a bit about the whole aspect of due process and what due process means. Due process, in a civil context, due process means to get a fair hearing. That means your ability to try to prevail with respect to a right that you have. The Fifth Amendment and the 14th Amendment of the United States Constitution says that no person can be denied liberty, property, or their their life without due process of law, which in a civil context, you give somebody a hearing in the sense of, let's say, a driver's license, they get an administrative hearing at DMV where there are standards of proof that need to be met before somebody can lose their license or their license is taken. In a criminal context, due process means that you have a right to a trial. And here in the United States, you get a trial of a jury of your peers. Now, a jury of your peers is a relative term. And I see Damon laughing because, you know, if you go to, if you're in the Bronx, let's say, you get, primarily the individuals that come through in the Bronx as defendants are black and Hispanic. Primarily the juries are going to be comprised of black and Hispanic. Not that it is necessary to get a particular demographic in order to get a fair trial. I've done trials in Rockland County with all white juries. I've done trials in Westchester County with all white juries and prevailed. But when you talk here in Westchester County about the types of jurors that are brought in terms of them sending out the mailings and the kind of individuals who actually show up, it is primarily Caucasian. You get a smattering here and there of blacks and Hispanics. And during the course of what they call voir dire, which is jury selection, the prosecutor gets a certain number of challenges as well as the defense in order to strike jurors, potential jurors. And they're not technically supposed to use their challenges have to be race neutral in terms of the DA to strike jurors. But there have been cases, and the seminal case is a case called Batson, where jurors of African-American descent were struck off by the prosecutor, specifically for race reasons. So the reasons that jurors have to be knocked off have to be race neutral. But the reality is, a lot of times DAs will create reasons to knock off jurors of color and predicate the reasons on so-called race neutral reasons. So you end up with juries that are mostly comprised of Caucasian individuals. And we know that many of the individuals who are coming through the system are, as indicated, black and Hispanic. I just finished a jury trial about a month ago on a Jamaican individual, and there was a young lady that said to the judge that she needed to speak to us in private. So I had already guessed that she wanted off the jury. So she comes in, the other jurors are excused from the room, and she says that the reason why she cannot serve on this jury is because that her house was burglarized years ago. The individual who burglarized her house was never caught. And the defendant, my client, was black, Jamaican. And because he was black, she could not serve on the jury. I started laughing, and I looked at my client, and he couldn't understand why I was laughing. So the prosecutor said that he had no questions for her, and I said, I have a few questions. I have a few questions for you. And then the first question was, well, you said that your house was burglarized, the individual that burglarized your house was never caught, but you can't serve in this jury because my client is black. Well, clearly it wasn't him because the individual was never caught, and you're basically just trying to get out of jury service. You didn't have to use a racist indication as to getting out of jury service. Just say the reason why you can't serve. But it's really, it gives the jury system a black eye when you have people who come out and say those kinds of things. And I don't really believe that the individual saying that was racist. She wanted off the jury, and she thought that this was the best way to get off the jury. So she ended up getting knocked off the jury, and we went forward. And fortunately, we picked a good jury. Case got tried, came back not guilty all counts. It was a gun and 10 pounds of marijuana. My client was Jamaican. I thought his goose was cooked. Because when I addressed it at the beginning, I said, how many people, if I tell you my client is Jamaican, and you hear that there's over 10 pounds of marijuana recovered at his house, is there anybody that's going to be conjuring up images of Bob Marley smoking a spliff when they're looking at my client? You know? So it was a joint task force, FBI, Westchester County Police, Mount Vernon Police, that went in, raided my client's house. They found over 10 pounds of marijuana, a gun. 5 different officers testified, and my client never testified, and he was acquitted. And this was a primarily Caucasian jury. I had 2 black ladies and 1 Hispanic lady on the jury, and they listened to the things that were being said. They listened to my cross-examination, and they didn't believe what the officers had to say. And here's why. The reason was because I actually...
I'm going to interrupt you
Yes,
so I
sir.
can say a few things.
Oh, I'm
Thank
sorry.
you.
I apologize.
But I do appreciate, because we're all in the same boat. The fact of the matter is we have trouble with our system. And I'm here tonight because I want to put out the word to the NAACP because of some of the things, and I know there are going to be some questions, so I'm going to be quick, and you guys, we can have like a back and forth. But the fact of the matter is we have issues in terms of a lack of representation, competent representation. We have issues where young black men are being pled out, which you've seen numerous times, and you've handled a lot of pleading out. And they're going to jail and doing a lot of time because they...
Can you explain when you say pleading out?
Pleading out means that I've had people and families that come to me, and sometimes they don't have the funds to hire a lawyer to actually challenge the system, because in Westchester it's truly challenging the system from the judges on down. In the cases, and I'm sure my colleague here knows, we call it the third prosecutor. We had 2 prosecutors that were against us, and then we had the judge who we thought was also a prosecutor. So it's very difficult on White Plains in Westchester to get fairness. And I say that out of my 25 years of practicing law, that it's something that we need to bring to the group like this, and therefore we can challenge the system. Pleading out means that sometimes if you've committed the crime, that might be a good thing, to take a plea or a lesser offer of the time that you would get if you go to trial. But a lot of times these young men are innocent, and because of how the judges, and you know, I'm not anti-judge, I'm part of law enforcement, I've been a DA, we've been on all sides. But when you have the judges pressuring, if you take a plea to this, you get 6 years, and if you don't, you're facing 15. So we have a very flawed system, and therefore a lot of the young men are doing this turnstile situation, turnstile justice, and oftentimes lawyers have to choose between their clients, because a lawyer might say, you know, this gentleman may have to plead out because the judge may favor me on this particular case. So, you know, the judge is pressuring me on this one, but I have this one, maybe I can get a win on this one. So it's a lot of pressure on the lawyers. It really is to fight the system in White Plains. We find that there is a level of appeals that they lose. They have a high rate of losses when there's appeals. That's my understanding based on the research that I've seen, which means that people are going to jail, and if they cannot afford an appellate lawyer or an appeal, they may stay in jail. If they may stay in jail during their appeal, and therefore, if they win, then they get let out, but then they've been in jail. So there are just, we have problems, and I'm going to point to this courthouse up here in White Plains. I've practiced in Manhattan, I mean, not Staten Island, I don't know what it's like over there, but I have a sense. But I've never seen this before. So we have a lot to discuss, and hopefully you have some questions.
Yeah.
Sure. You get this?
No, I'm just gonna, I'm
We
just
can
gonna
hear-
talk, yeah. I don't know if y'all are familiar with the recent case of Selwyn Days. And disclaimer, I mean, the man's been in jail for 16 years. I've seen him, I had him a couple in my housing area. And Frankie, I think you know what I'm talking about. 16 years, five trials, and the last trial acquitted on all charges. That got to the press, but is that common for young men and women to fight on instances like that? Because he had everything stacked against him, but he continued to fight.
Well, the only thing, and of course the NAACP here has promoted throughout their history, the need for jury service. Some of us who work, we want to get out of jury service because we have to go to work. But that is the defense in the justice system. All we have is you. If we can't get it from the prosecution, we can't get it from the judges, we have to go to the jury. The jury that I last tried a murder trial, a 7-week trial. They said it was historic up in the courthouse. We were like sheroes. It was 2 black women, myself and my colleague from Manhattan. And we won the case, major victory. But we had to take a chance. The family was willing to roll the dice. My client was facing 25 to life. I come into cases because I have the belief of his innocence, so I'm not just there. If I see this, I'm going to fight for him. We fought hard, but what we thought gave us hope and confidence that the jury system worked. We had African Americans, we had from various islands, we had a cop at 12, or it's a hung jury. When we sat there, we thought it was 11-1 against our client. We said, no way, we saw the jury, we rolled the dice, and it was 11-1 the other way. And we believe it was the police officer that was the holdout, and he came around. The jurors were from Mount Vernon, all over the Chappaqua, and I was proud of the jury because they heard it all. And it is very tough to get a fair trial because we've seen what the prosecution has done. There's a lot of things we can discuss about what their strategy is for forcing these pleas and the things that they've done. So I don't know if there's any...
I wanted to, Peter, you on Facebook,
David, we need you to use the mic.
Yeah. Oh, here you go. All right, well, let me stand.
Yeah,
Okay.
right.
Peter, you on Facebook, you made a post about your defense of a client that was found not guilty. And one thing you said that the press doesn't cover when they're not guilty. They only cover when they're guilty. I want you to talk about that.
Well, you know that the district attorney's office, it's all political. It's a political position, and most people want to believe in this so-called criminal justice system, that it works, and they want to believe that when the police make an arrest, they've arrested the right individual. Unfortunately, that's what trials or fortunately, that's what trials are for, is to make a determination of that. So anytime there's an arrest and a prosecution, there's a great deal of fanfare that they've made the arrest. We have the person that committed this particular crime. Channel 12 News, files, it's run in the Journal News, local stations cover it. But what they don't cover are the types of things that took place during police investigations, improprieties, where false confessions were obtained, where individuals who can barely read and write are signing off on typed confessions that they did not type, where individuals are being interviewed in advance of being on camera and for an hour to 2 hours to several hours, and then they turn on the camera for a half an hour so-called confession. But they don't show what preceded that. So I had done a double homicide trial in the Bronx in June. Client sat at Rikers for 3.5 years. He went in at 18, he came out. We did the trial and he was acquitted of both homicides. No cameras. There are no cameras. I walked the young man out to the front of the courthouse. But for me posting on Facebook, nobody would have known that this young man was acquitted. But the case, when he was arrested with his co-defendant on the double homicide, it was all over the local news, it was on channels, TV channels, but they never seem to give the same amount of focus and attention, because there has to be the appearance to the general public that the system is working, that the system is working correctly, that we have the right person. And the system is very reluctant to admit that they've made a mistake. But that's what jury trials are for. That's what jury service and people, lay people coming out to serve on juries, to keep DAs honest. Because as much as they say, DAs, that our job is to see that justice is done, their jobs are really about self-fulfillment in terms of obtaining convictions. Because that's how they stay in office. And make no mistake that this is a business. Corrections is a business, police is a business. This is big business for the United States in terms of arrest.
You want to say something?
Yeah, I think, you know, during the time that I have here, there has to be conversations, because we had a lot of hope in the new DA. You know, we had changes in the guard up there. I don't know what's going to happen and if there's going to be changes. So there needs to be a push to meet with him every week. I don't know if the NAACP meets with him, asks about cases, and the pressure has to be placed on, because I can tell you, just like my colleague said, it's horrific. Okay, it's horrific. I've worked, and sometimes my colleague doesn't get the respect, because he's sort of, even though you had the stint as the ADA, you've done a lot of defense. So people will say, okay, you just defend, so you're going to say that. I have been on every side, and I have worked at the highest level of law enforcement. And I can say it is horrific. And I'm calling on the members of this committee or this organization to sit down with this new DA, because what we saw in the trial we had, if that is something that they do, then we have a total abomination of the criminal justice system in Westchester. We had police officers who took the stand. The first cross-examination was how many convictions the police officer had. So that was the first thing. The first 2 police officers had convictions themselves, and some of them were convictions of assault without any type of disciplinary action. So those were some of the prosecution's witnesses. Some of the other prosecution's witnesses, they were given 6 months, and like I said, I know about Greenberg, because the gentleman that was involved in our trial was a sex trafficker that was in Greenberg that skipped out of the courtroom because the prosecution offered him so little time to testify against our clients. This is the game. So we have these young men, and then they're saying, oh well, I just got 6 months. I have a gun charge. This gentleman had 2 gun charges, sex trafficking charges. They had to get him out of South Carolina. He was using other people's IDs. He was doing everything and received 6 months for testimony against my client. So, and we had something that was, and I have to say this because the people here have to know, we had something unprecedented. Because the prosecutor didn't know who we were. We're not really the regulars in the courthouse. So they weren't clear on who we were. So they began to give us stuff. And one of the letters that they gave us was one of the witnesses had written a letter talking about the police officers using tactics and harassing and going to his mother's house and all over the place and trying to get him to testify. He wrote a letter and the prosecution had to turn it over. And we'll talk about what has to be turned over. We'll talk about what they call this Brady. And they're not turning things over. They're not being forthright. We force the issue because these young men are being railroaded. And I don't say that lightly. I'm a little older than you, so I'm not here to say it. And I say it because I'm giving you the backup because I've represented. So you can't say that when I represented Elliot Spitzer, I'm right and everything I say is right. But when I say it about the criminal justice system, I'm wrong. So I'm right on both sides. And this is an abomination that we have to stand up for because innocent people are going to jail and they're taking time. I've sat in there when you've taken pleas. People are going 10, 15 years like it's nothing. And these are children, young men. And it's no joke inside. It ain't no joke.
I wanted to briefly follow up on something that you mentioned, which is Brady material.
Right.
Yeah. What that means is that prosecutors are required by law to turn over items which are considered to be exculpatory towards defendants so that they can present those items as a part of their defense. What routinely happens, and it's not only in New York State, what routinely happens is that DAs are very remiss and reluctant to turn over tools by which defense attorneys can use to get their clients acquitted. So what ends up happening is prove their innocence.
It can be used, for example, just to piggyback on that real quick. We had an issue with videotapes. My client, they allegedly saw my client doing things on videotapes. Those videotapes were lost. Every police officer that touched them, nobody knows where they are. They all go through this Ponzi, 3-card Monte type deal. Not only was one videotape lost that was of one location, another videotape was lost of another location, and then another videotape was lost, and then a particular photo array where allegedly someone pointed out my client, that was lost. We're talking about areas of insidious behavior because they're all lost. But we had to push the judge to let us know that early because we wouldn't have known it. Normally, you don't get this information except right before trial. They have an obligation to turn it over to us when it's believed that not having it, it could show my client's innocence. They have an obligation to do it, but they make judgment calls saying we don't think that's what it is. So it's a mess. It's a mess.
So, let me ask you a question. Now, how do you guys fight it for your client? You know, because now a lot of people here, they're like, wow, we didn't know that. But how do you fight it if the system is that way and as lawyers? You know, how do you fight it without, you know, I mean, a lot of us are just hearing about it now, right? So how do we move forward in fighting it?
Well, I don't believe that those items that you mentioned were lost. You know, that's a euphemism for saying that they were destroyed because they don't want their case destroyed, and they're not going to admit to the destruction of evidence because that's the kind of thing that they can be prosecuted for. So they're going to say those items were lost, but what's the probability of 4 or 5 videos and all being lost? It's slim probability. So they do this, they specifically suppress the exculpatory evidence or evidence that tends to show potential innocence on purpose to obtain convictions. But when you do that, you're really denying due process. You're not letting the system work the way it should work because, as indicated, this is political and they're about percentages. The federal government has something like a 98 or 97% conviction rate. They have that conviction rate because really the deck is stacked routinely in their favor. The feds tend to play a little bit, a lot more fairly because they turn over things that you're technically not even entitled to in an excessive caution. And everything is done on the record. There are no sidebars that they do like in state court where they go off the record. Because the reason that they do that in state court is so that somebody can't review it for the purposes of appeal. Okay, because when they read the record, all that's on the record is that there was a brief sidebar. Well, what was discussed at the sidebar? If it's a legal matter, it needs to be on the record to be preserved for appeal. Because that's the only way you're going to get an appellate court to review it to decide whether or not there was a mistake here that occurred and whether somebody should be granted a new trial. So I see somebody raising their hand. They have a question.
I'd just like to ask that something like that, isn't that a crime? Shouldn't somebody be held accountable?
Well, we don't have a system, and I talked to some people that are part of an organization. They're trying to pass a bill which they're struggling to pass. And this was spearheaded by by a Caucasian man who was actually wrongfully accused of a certain crime. So there is legislation they're trying to pass to hold the prosecutors accountable. That hasn't passed. Of course, the DA's organizations are going to fight and fight it hard. But with the education of this organization and various groups, by sitting down and even talking to us later on about the things that, for example, in my case, we had rap music on trial. We have an expert right here, AJ, that we had to call in because my client had a rap video. And based on what was said in the rap video, they tried to connect him to certain behavior. AJ had to come in as one of our expert witnesses to talk about, I shot the sheriff. That person didn't go to jail because that's just, a metaphor, and rap is the only genre that you can, as you could say, I won't take your spot there, where you actually believe what it is they're saying. So, they tried to tie him to a gang. So we talked about the Sugar Hill Gang. That's not a gang. We talked about Cool in the Gang. That's not a gang. So gang, just using the word gang, became an issue. It's on fire in there. Help us.
You asked the question, isn't that a crime? Yeah, it's a crime. But look who's committing the crime. It's the people that are enforcing the law. Do you expect them to police themselves? Do you expect them to prosecute themselves? That's not going to happen. So when you ask, what is the greatest crime that people commit? Well, the greatest crime that police officers commit when they take the stand and they testify untruthfully is perjury. Everyone knows perjury is a felony. It happens routinely. It happened in the trial I was talking about when the cop said he saw my client going in and out of a skylight that you clearly could not see from the backyard of his house. And I put in the video. The DA didn't put in a single video. I put in video that I took. I put in photographs. that I took that showed you couldn't even see the skylight. That's why the client was acquitted. And what happened to the officers? Nothing. Nothing ever does. They can blatantly lie in the stand, perjure themselves, and routinely. When was the last time you heard in the paper, the news, anyone being prosecuted for perjury? It is just known that this is what people routinely do in the stand. It's a shame. It should open your eyes that just because somebody puts their hand on a Bible and says they swear to tell the truth, they don't. Okay, that's like, you know, curling your pinky and saying you're going to tell the truth.
Question?
Do I need a mic?
No, you can speak.
Okay, so basically the question is what?
Couple of fronts. The most important thing is to put everybody on notice. So by this organization wanting to meet consistently with the DA and observing the courtroom's public. Even if the Criminal Justice Committee has people sitting in the courtroom, the judges, the way they talk to the defendants, just the way they talk to the defendants. I step in the courtroom, they don't talk that way anymore. I had one judge, I can't mention his name, in criminal court, and I say that because when he saw that we were watching, he slowed down the process and what they call allocuting. That means when you get ready to plead guilty. He started saying, "Are you sure you want to plead guilty?" Right. I mean, because then my colleague is from Manhattan, I'm from Mount Vernon, they've never seen us, so we're in the courtroom, who are we? So now we're watching, so all of a sudden it was just slow. Before it was like, are you pleading guilty today? You get 7 years today, 16 if you don't plead guilty. You know, the client is looking at his lawyer like, what should he, like, I don't know. So that's how it was, but when we started questioning, I mean, we went hard. We went very hard on the system with this case. So what was happening is they were slowing down. Sir, you know you have a certain right, and it started slowing down. So by observing what they're doing, that is also helpful. So that's part of it. And then there's this organization that is set up to help to try to get a prosecutorial misconduct commission, like the Judicial Commission, the lawyers have the commissions, et cetera, et cetera.
Hi, I was listening to you talking about lost video footage and stuff like that. So I'm thinking like, how do they change like policy and procedures? Is there anything in place where, like say for instance, they say they have videos and once the lawyer, the client obtains a lawyer, is it supposed to be turned over to them? So now if it disappears and stuff like that, somebody should be held accountable. Like, all right, you did say you have videos, and you have like
no one's held accountable.
Legal documents, like we used to have we have legal documents, so if anything went wrong, it always came back to that person who was on duty at that time, who was assigned to that sector and so forth. So how do you change that?
Well, that's a policing issue.
Well, how do we change that?
Well, I don't know how to change the policing issue. I mean, we know what has been done in the case. There's a federal lawsuit that has been filed in hopes that in that federal lawsuit, in hopes that there will be change. But I think the way the system operates,
Let me try to answer that.
there's monetary, they rather do it monetary than change the system.
Right, let me try to answer some of what I think your question is, Mr. Green, who's a very close friend of mine, by the way. What I think that you're saying is how, in the context of a given trial, how do you deal with officers saying that videos were lost, items were lost? Well, what you can do, and some of the judges will allow you to do this, is ask for sanctions. And the sanctions against because even though the prosecutor may not be responsible, he's responsible, not personally, but he's responsible for what his officers do in the course of the prosecution. So what a savvy defense attorney does, it says, well, okay, the box that they claim that the gun was in as part of chain of custody was lost. They claim it was lost. What I'm going to ask for you, Judge, is to give what is known as an adverse inference instruction to a jury that says that if the box was present, that it might contradict what the officer had to testify to. So in the context of the actual trial, there's certain sanctions that you can ask that the judge take against the officers by way of that particular case. There's nothing that you can do as a defense attorney to address malfeasance on the part of the officer during the course of the trial, but file a formal complaint with his superiors. And that probably is not getting very far because the police unions are notoriously strong.
Let me
Real quick, the question, as lawyers, now you get this evidence late, and now you go to trial. Now you present that to the jury. And to me, it's just a problem with people supporting the police. Or ain't nothing wrong with supporting the police, but it seems like the police can do no wrong. But if y'all come in and tell me like this video was lost, this video, and I'm a juror, I'm not trying to send nobody to jail if you don't have that proof of evidence.
Well, they didn't.
No, they didn't.
They didn't send the person to jail. We were able to make that case.
I'm just saying, I just see and hear and research so much foul play with certain cases. You know, it just makes you second guess the system. The system is corrupt. Everybody know that.
Yeah.
But even though, you know, one of my best friends, he's a cop. You know what I'm saying? I know he does a great job, but some people are just corrupt. So it's just like it's hard to change it.
I think just to piggyback on what you were saying, what is the sanction? And I want to just reiterate, you said adverse inference. An adverse inference, as we said again, is when you, if something is lost or whatever, you won't say lost, but when something is missing, you can say to the jury, by that document that's no longer there, you can make the inference that that would have shown the defendant's innocence. Now, my client was scared to life, to death, because he never wanted to get to a jury. He felt that the jurors may not understand that instruction, possibly, because it was a legal instruction. My client, who maintained his innocence throughout, said, why do we even have to, we want the judge to make the decision. And we want the judge to make the right decision on Brady. When you see the prosecution's case and you see what happened, then you need to toss the case. But why make the defendants go through an entire trial thinking that the juror's going to understand, you know, this adverse inference, and if they lost it, you can possibly use that as evidence to show the client's innocence. So that's the backdrop. We wanted the court, the judge, to toss the case based on all of the violations and the impropriety, not send it to the jury and hope that it works out.
You know, that the concept of judges following the law is an actual rarity. and I say this with all due respect to the criminal justice system, but at the end of the day, these are political positions, and the judges have to own, and especially here in Westchester County, because they want to seem as though they're an arm of law and justice and police, so on and so forth. And so it's no wonder when you think of due process and trials that police officers that are accused of crimes, they don't ask for jury trials.
No, they don't.
They ask for bench trials.
That's right.
Because there's no judge who's going to find them guilty of virtually any crime in 99% of their cases. So defendants don't have that same luxury. They can't say, Judge, you know, I'm accused of this egregious, heinous crime, and I want you to acquit me because of the malfeasance of the officers. That's not going to happen, because the judges don't have that kind of courage to do the right thing. They're going to do the expedient thing, the politically expedient thing, which is going to get them reelected. All right? So when it comes to the cops, they'll acquit because they have to work with the cops. They have to work with the DAs. That's a natural tendency, and we have to be realistic. One of the things that you can do as members of the public is to show up. Show up at trials. Show up at a trial where you think, You had Selwyn that went to trial 5 times. There should be people to the front of the courthouse
That's right.
with signs protesting why this individual is being, because that's unprecedented. That somebody's going to trial 5 times. Clearly there's a problem. Clearly that maybe it's time to let it go. But the DAs don't do that because they don't want to be looked upon as being soft on crime.
Your brother in the back.
Good evening, everyone. I'm really enjoying this conversation, and obviously there's a lot of collusion that goes on within the court, especially within Westchester County, between judges, district attorneys, even some defense attorneys, especially if they are legal aid. And a lot of it has to do with statistics, and it has to do with wins and losses, that I understand. My question is in regard to the fact you have United States laws. Different states have their own laws. New York State happens to be more strict than a lot of other states in Westchester County. It's an altogether different story in itself. But I believe that the conviction rate is, I would say, above 95% in Westchester County for especially Afro-American men that go to trial. And my understanding is that those that can afford an appeal, or if there is a court-appointed attorney for appeals, that the overturn rate is above 70%. So obviously there's something wrong with the system in itself. My question is, even if there is an overturn on appeal, because I do know attorneys shepherdize the law in regard to putting their motions together, if there has been a case that has been set as precedent, how come there's no law put in place in regard to avoid prosecutorial misconduct or judge acting out of order? I know that a judge is immune from any type of prosecution, but I believe that we could come together as a voice to invoke changes in laws. Also, in regard to African-American men and women within New York State, there is no expungement of their crimes, so in actuality, they are doing their sentence in society for the rest of their life. And there's something wrong with that, because once you have served your time, your slate, according to the law, should be wiped clean. That's pretty much all that I had to say. My question is, though, are there laws that can be put in place in regard to people coming together and lobbying for different changes?
Well, what's now on the, before the Senate, or they're trying to get it up, there's another organization, I think you met her, NADA. Yeah, she's part of that group, which I can't remember, ICI. Yeah, the ICI. I can't remember the acronym for it. But this is an organization, because I was in Albany, and they were going to each member of the Senate, and they were going around to various other assemblymen to lobby for a prosecutorial misconduct commission. The problem is we're scared. You know, you want no chasers, I'm going to give it to you. You have to have complaints.
Right.
People are fearful of having complaints against judges. People are fearful of having complaints against police officers. People are so fearful of all of these things, so nothing changes. So, for example, if you have a judge, there is a judicial misconduct commission. And, you know, you can file a complaint against a judge if he or she is disrespectful. I know that a judge that I was before grew up in Mount Vernon, so she had a perspective about when Mount Vernon was, what it was like when she was there. And that look of Mount Vernon, the perspective is she was pissed off that it didn't look like that now. So she had a perspective about Mount Vernon because she came from Mount Vernon. So you guys have to be, I think, more active in the court system and advocate for a commission on prosecutorial misconduct commission. And the fight is going to be hard. I mean, you ask, for example, you meet with Anthony Scarpino, the DA. Are you for a prosecutorial misconduct commission? Why don't you get behind that? Maybe you want to ask them that.
You know, to follow up on that, you gotta hold them to their obligation. And what I mean by that, they're public servants, right? The DAs work for you. They're elected positions. The judges work for you. They're elected positions. All right, so they may go around to solicit in terms of fundraisers every 10 years when it comes for time to get reelected. But my point is that everyone gets policed. Defense attorneys get policed by the bar, the grievance committee, all right?
All attorneys.
Judges get policed by the judicial grievance commission. So, I file complaints against judges. I'm routinely hated in many courtrooms in Westchester County, Bronx, Rockland. I file judicial complaints. I am not a stranger to that. I'm known for doing that because I'm very big on requiring that level of respect for clients.
Yeah. And then you.
I don't know if most folks know, this year, during the election coming up in November, we're looking at changing the New York Constitution. Okay? It's a very big issue because the governor is pushing that to make certain changes. Since you guys are lawyers, what criminal aspect of the Constitution, okay, will be changed if the governor gets his way? How will it affect us?
I have no idea what the governor's gonna do.
I can't speak to that, but what he should do, to follow up on what you were saying about expungement, should be to expunge, and there's been talk about this.
Put it in the Constitution.
Yes, to expunge criminal records of individuals after a certain level of time. Because what happens is, you know, we're talking about fairness, all right? You have young men that are coming through in Mount Vernon charged with criminal possession of marijuana for having a minute amount of marijuana, more than 25 grams, who get criminal convictions for life. For life. If they don't have youthful offender status, they could be 17, 18 and have a conviction that shows up 30 years later when they're going to apply for a federal job, for a state job, for something in aviation, whatever it happens to be. That shouldn't happen. Especially it shouldn't happen because when it comes to marijuana, they're now looking to push to legalize it so that they can make millions of dollars off of it. But these young men and women have to take convictions for the rest of their life for the same thing. Something is wrong with that.
And we're drawing analogies, and this is what we sit back and talk about in the bar rooms, not bars, but bar rooms, and bars, among our colleagues. So for example, you know, you have this, we see a difference with the opiate or opioid, what do you call it? Crisis. And that it's decriminalized, but crack wasn't. You see, you have to stand up for this inequality, and I want everybody to get treatments that's needed. But folks that had a crack vial, they left here for a long time. But now there is a push for the opium epidemic to get funding for treatment and not criminalizing the possession of it like they criminalized crack. So I'm saying, my sisters and brothers, whether they're Caucasians or not, the beauty of that jury that I was in front of, they got it. Okay, they got what happened in our case. And they just left and went back on wherever. They didn't look at us or anything, and they walked out. But they did their job, and they're not stupid. And we have to put it to you guys that this is the kind of inequities that we're seeing. Billions of dollars are coming in for health care for this epidemic that we believe is challenging the Caucasian community. We've never heard of the opiate epidemic in Harlem. I mean, and I know it exists, but crack was the issue. And young men were going, and matter of fact, they upped the punishment in terms of one crack vial and the weight. So we're only pointing out, because at some point I'm retiring, I'm out, you know, he's gonna go off, and if we won't be here to fight the battle. So you guys collectively have to fight this battle.
Are we gonna take one more question?
I just
And
have,
then we're gonna, because it's almost 9 o'clock.
yes, I just have one question. Who would sit on, what type of people would sit on that review? That you're, prosecution review? Like, who would sit on there?
What-
I'm just curious.
Well, what they're proposing is a
Right.
cross-section of the community, lawyers, members of the community, so it's a cross-section. And their whole, they would review cases, say somebody had a complaint, they would review cases, et cetera, et cetera, et cetera. I think it's needed. There's no oversight for the prosecution. And I was a prosecutor. This gentleman, my colleague, was a prosecutor.
I guess it would be kind of like the Civilian Complaint Review Board, similar to that, but it would be a great way to keep DAs honest. And one final thing, when you're talking about conviction rates, because it's an illusion, when they talk about conviction rates, the conviction rates come primarily from plea bargains. People plead out. The majority, if people were to stop taking as many pleas, they would halt the system. The DAs would be forced to give better offers. The individuals who are going into prison for nonviolent crimes would be diverted primarily. So there are ways of dealing with this that people just have to get together and figure out creative ways of holding the district attorney's offices honest.
I want to thank both of y'all for, there's a lot of information. And we're definitely going to have you back so we can recap. And can you, well, Nada's doing that, right? The prosecutor?
Yes.
So we have to get with Nada, bring her in front, let her give us an update. Also at the Lower Hudson Valley Political Action Committee, they have a petition. I'm going to post it on the Facebook group to end the privatization of the healthcare at Westchester County Jail. So I think that's something that everybody needs to get on that. We need to bring back actual county workers, people from our community that's going to care for the people that's inside. But before I end, I want to bring up Brother Neil Reynolds, who's a lieutenant, just to talk real briefly about the police, New Rochelle Police Department test.
Thank you. Can everybody hear me?
Yes.
Okay, good. I'll use the microphone. Just a little bit of background about myself. As Brother Damon said, I am a lieutenant with the New Rochelle Police Department. I am in my 24th year. I happen to be an attorney as well. I don't do any criminal practice because I'm good for doing that. The county I work in and pretty much all over. But just a couple of things. Like Mr. Davis just said, that there's a really interesting article about plea bargaining, and I think it was last month's Atlantic magazine, about plea bargaining and why plea bargains are done, and it would bog down the system if it did occur. To speak after hearing that about people becoming police officers, some might find that difficult to do. However, some of the things that need to be said are something that was said earlier about voting. You need to get out and vote, and that's a watchword, and you need to get out and vote so you can be on the jury. That's one thing. You need to be, and we need to have more police officers of color so that we can make people slow down when they walk in the room, when they see things happening. I know I'm the commander of the first tour. That means I'm in charge of all the police officers in the city of New Rochelle after midnight. So there are certain things that I make sure happen, certain things that I need to be in the room for. I trust all of my officers. I know some people might not, but I trust all my officers, and I train all my officers to see things that they may not see, being police officers that are not of color. I'm able to say to them, well, if you do this or you say this to a particular person, they're thinking one thing. You might do it with no bad intentions.